Y'all bow with me, please. Gracious Heavenly Father, we come asking you to forgive us of our sins, to lead, guide, and direct us. Keep your hand on us. Let us do things that are pleasing in your sight. Give us the knowledge so that we do things for this state that are not harmful. Bless us, guide us, and lead us. In Jesus' name we pray. Amen. This is, we're going to first talk about what today's calendar, what's on the agenda for today. Mr. Lindsay.
Mr. Chairman, I have two motions. Pursuant to Rule 33.3, I move that the debate regarding HB 636 regarding the city of Ashford be limited to 1 hour.
Let me interrupt you for a second. Do an hour and a half on both of them.
Be limited to 1 hour and a half. Time to be allocated at the discretion of the speaker. You've
got a motion. Do I hear all in favor? Any opposed? No. The ayes have it. Even though the no was actually a little, yeah.
All right, Mr. Speaker, Mr. Chairman, I have another.
Do you want to go on first? Go ahead,
Mr. Chairman. I have another motion as well regarding HB 824 regarding equalization. Also move that the debate be limited to 1 hour. Time to be allocated at the discretion of the speaker. Unless you want to do an hour and a half.
Do an hour and a half.
I'll do an hour and a half, Mr.
That's a form of motion. I have a motion and a second. All those in favor signify by raising your right hand. All those opposed, raise your left hand. Okay, motion carries. It was unanimous.
Anything we can do to get your vote.
Okay. Mr. Knight.
Thank you, Mr. Chairman. Bring for your consideration House Bill 875 that's under the modified structured rule. This is something the Department of Natural Resources, the Wildlife Division, brought to our attention. As you know, our hunters, fishermen, boaters out there all need a license and apply for a license, and those license fees are what we manage our department, our wildlife, and our resources for. But it's come to our attention that a lot of people out there are making open records requests of the department to get all of our personal information from those licenses. In fact, it's gotten so bad that the department just regularly puts out at the end of the month, I'm told, a batch, just batches the information out there. So what HB 875 seeks to do is make sure that these records are not open or subject to open records. And if you'll look on the bill, it's basically, you know, the license, the driver's license, the identification number, home addresses, phone numbers, personal emails, text, medical or disability information, bank accounts, any federal government ID number, and such forth that the department may collect. I'm not sure why we would want to put our hunters, fishermen, and boaters information out there in the first place, but apparently it's a lucrative business. A lot of the marketers and people are doing this. The second thing this is doing is it's really inhibiting the Department of Natural Resources from using our technology to communicate with our users of these licenses, because what they're trying to do is use those things and text us. Mr. Chairman, your license is expiring in 2 weeks. To let you know that, or there's a change in a hunting season, or some of our game laws or boating laws, and people don't have the confidence now to give that information to the department. So that's what this bill seeks to do, and I would appreciate your favorable consideration, HB 875.
Any questions?
Yes, sir.
Wait, Mr. Mosby, who's 38 got their button pushed? Okay, all right. Mr. Yep.
Chairman Knight, I appreciate your bill, and I agree with what you're doing. I guess my only question is, we have a bill right now in judiciary that's going to be an overhaul of the entire Open Records Act. I'm just wondering whether or not we could take your bill and simply morph it into that one.
Well, Mr. Whip, I'm certainly, I say not opposed to it. Our initial idea was, though, that y'all had a pretty wide-ranging bill addressing the records laws in general. We're very, very limited in what we're trying to do, and very specific with our hunters, fishermen, boaters, the people up under this Title 27 in regards to trying to keep it very, very narrow. We're not trying to get into, I guess, the larger scope, and that was why we were trying to avoid getting into that battle. I'm certainly.
Well, I'm not asking you to go into that battle.
Yeah.
So perhaps the better thing for me to ask is just keep an eye on that other one and make sure that these bills complement each other, and that we don't end up with two bills where one has to be vetoed because the language isn't, or the code sections don't mesh. That's
okay. And certainly, that is not our intention. So,
that's all. I like your bill.
Thank you. Ms. Carter.
Thank you, Mr. Chairman. I come before you again this morning to request HB 895 under structured rule. This is the bill that transfers the sex offender investigators from the Sex Offender Board, which is under DBHDD, over to the GBI for reasons of access of criminal histories, so that they can better level the risk on these offenders.
Any questions? Good.
Thank you.
Mr. Ramsey.
Thank you, Mr. Chairman. I'm here on House Bill 879 in the modified open rule section. It's a bill to provide for training for school personnel where a diabetic child attends that school.
Any questions? Thank you.
Thank you.
Good doctor.
Thank you, Mr. Chairman. Good morning. I am here on House Bill 845 under modified open rule. This would require early child care centers to educate the parents about influenza vaccination. Influenza vaccination is something that is not well penetrated in our population, and this would help with that. It does not require influenza vaccination, and it does hold the child care centers harmless.
Mr. Benton.
Thank you, Doc. I was wanting to know, does your bill put an unfunded mandate on the child care centers to have to do this?
Well, if it would be unfunded if you count logging on to cdc.gov and printing out 2 pages of paper. That would be the mandate that they would have.
Okay.
Thank you.
Thank you.
Mr. Nimmer.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. I bring before you House Bill 817. It's the annual GDOT house cleaning bill. We're also going to have an amendment that should be on your desk that we're going to offer today in rules with this bill, that just a late change that we wanted to make, felt it made the bill better. To go through it as briefly as possible, Section 1 gives the department the ability on negotiated contracts to go from $100,000 price limit to $200,000. If you'll see there, it says prior to the amendment, $250 in the bill, but as at the appropriate time, Mr. Chairman, I just want to add that amendment along with it. Section 2 and 3 lets us have the ability to take away the mandate to have the bids read on a monthly basis, where in the past 6 months only one person has come in and actually heard the bid readings. That way we can just catch up with advancements in technology and allow them to read that or post that on a electronic base publication. Section 4 deals with design build projects, changing the abilities from 30% up to 50% design build partnership for projects in the state. Section 5 removes the step in the process for the department to expend funding on local routes. That'll be incorporated with a state project so that they can expedite and get through a project in a quicker manner than what they currently have to deal with. And Section 6 allows the department to close or limit portions of the state highway when terrible weather comes our way, such as you all experienced last year here when the General Assembly kicked off. The department just needs the abilities to go out and post closures on roads and make sure that folks do not access roads that would be in danger to them, and also implements the requirement to have proper equipment on your vehicle whenever you're traveling in that weather.
And there is no Section 7, 8, and 9, are there?
I'm sorry. Let me back up, sir. I'm reading off my notes. Where are you? Say that again, Mr. Chairman. All right. Sorry,
Mr. Nimmer. And for the rest of you, this is supposed to be quick.
Yes, sir.
And I certainly don't want to use this gong on Chad.
Thank you, Mr. Chairman.
Are there any questions of Mr. Nimmer?
Thank you.
No questions. I assume that this is the, how many times have you been up in this thing?
This would be the one, yes, sir.
I thought so. I thought so.
Thank you.
Mr. Hightower, excuse me.
Morning, Mr. Chairman.
This is Dusty's first one, too, so brevity is really appreciated.
Yes, Mr. Chairman. I bring before you HB 733. It's under modified open rule. What this would do is allow for a holdover provision for the Georgia Commission on Family Violence. Most commissions in Georgia, just so you know, have a holdover provision. Just a couple of examples: it's the State Personnel Board, Veterans Board, Board of Natural Resources, State Board of Education, Board of Regents, Georgia Agriculture Exposition Authority. All these commissions and different boards throughout the state have a holdover provision, but this commission does not. The reason it's important is because September of this year, 24 out of the 37 will term off, so that's why it's needed.
Any questions? And we've had two erased there. Now, you did take Tim Bearden's place, right?
I did.
And I let him on that floor all day long, didn't I? Or all session long. No, Mr. Weldon, you have not got a question. Thank you, Dusty.
Yes, Mr. Chairman.
Thank you, Mr. Chairman. And to the gentleman from Mr. Bearden, what district is the Hightower district?
68.
Is it not true that the Highway Patrol barracks in your districts, is that named the Tim Bearden Honorary?
Okay, thank you. Go.
Thank you.
Mr. Battles.
Thank you, Mr. Chairman. This is under structural rule, House Bill 215. Just asking to consider, this is the bill that would prohibit convicted sex offenders who are on the state sexual offenders register to not receive a driver's license with the P or the S endorsement. Ask for your consideration again. No questions.
No questions. Thank you.
Thank you.
Mr. Tippins.
Thank you, Mr. Chairman, committee members. I'd call your attention under the modified structure of Senate Bill 231, the last item. I'd like to ask for the release of Senate Bill 231 to go to the House. We discussed this a week or so ago, I think.
Thank you.
Thank you so much.
Mr. Williams.
Thank you, Mr. Chairman, members of the committee. I'm here today to ask for your consideration of House Bill 886. This is a bill would allow the continued use of derivatives transactions by state-chartered community banks under the provisions of the Dodd-Frank Act at the end of this year. The state-chartered community banks will lose the ability to use these transactions on behalf of their customer base, absent a change in the statute of Georgia banking laws. And this bill enjoys the endorsement of all the banking associations in the state of Georgia. I ask for your favorable consideration.
Any questions? Thank you. Mr. Brockway.
Thank you, Mr. Chairman, members of the committee. Bringing your attention to House Bill 748 seeks to do a very simple thing, and that is to allow adult adoptees to obtain a copy of their original birth certificate. Presently, they have to go to court to get that and get a judge to unseal it, which can be very costly and time-consuming and doesn't always deliver a satisfactory result. And that's what the bill does, and I'll be happy to answer any questions, Mr. Speaker, Mr. Chairman.
Do we have any questions? Thank you.
Thank you, sir.
Mr. Harrell.
Thank you, Mr. Chairman. I bring House Bill 850 under modified open on first page. The first section allows immunity for medical practitioners following a physician's order, and Section 2 allows probate courts to do federal background checks prior to assigning guardianship.
Any questions? Thank you. Mr. Gassinger.
Thank you, Mr. Chairman. First page, modified open, House Bill 769. It is a housekeeping bill. It simply gets rid of copy filings that we have done for the last 13 years at the cost of about $3,000 to the state, and it simply allows us to not do that anymore since the information is available online. If there are no questions, Mr. Speaker, I yield.
Any questions? Thank you.
Thank you.
Mr. Welch.
Thank you, Mr. Chairman. Members of the Rule Committee, I have a request for modified structure rule, House Bill 745. This is the pulse ox screen study that would be done by the Department of Public Health. The second request is under structured rule, House Bill 289. This is a population ad valorem tax bill exclusive to Butts County. If you have any questions, I'm happy to take them.
Do we have questions? Thank you. Mr. Goodwick.
Thank you, Mr. Chairman. I'm going to ask again under modified structured rule. This is legislation HB 648 and the accompanying constitutional amendment HR 977. This is the measure that will go ahead and put the question to the voters on dedicating the existing fees, no new revenue, existing fees being generated for the indigent defense system to be dedicated for that purpose. Put a little more clarity to it than my explanation yesterday. I mean, we had funding issues in that system for years. We've been in and out of state and federal court for years. From a management standpoint, we do better, I think, to dedicate the fees, and it's just a floor. It's just a floor to that agency in order to avoid the possibility of a federal judge, frankly, getting involved in years to come, telling us what to do as to how we manage that system. There is an amendment that I had yesterday and also today that will provide that any surplus that are generated will go ahead and go back into the general fund just as with any other agency. in order to be consistent, and happy to answer any questions or concerns that might exist.
Any questions? Mr.
Thank you, Mr. Chairman. Representative Golick, sure. I want to make sure I understood exactly what you're talking about. I meant to ask this yesterday. When you talk about dedicating the fees, is this going to change the ability for a individual county to opt out of the system itself? If you're dedicating the fees, don't you have to be a part of the system?
Correct. Correct. It has nothing to do with opt-in or opt-out. For instance, our county is opt-out already. It has absolutely doesn't touch on that whatsoever. These are simply, this is simply for those jurisdictions that are in the statewide system right now.
Okay, so it does not require those that are opted out to dedicate the fees?
No, I mean, if there's any fee in the system right now that's generated under existing law, that which is generated is dedicated for that purpose, no more than that. If there's any surplus, it goes back into the general fund just as with any other agency. And again, the imperative behind it, and this is not something that we wake up every morning thinking, oh, how, let's go ahead and address this issue. It is specifically provided for in the Sixth Amendment. And so that's when it touches into a federal jurisdiction issue. And again, we've been in and out of court for years now on this thing. And so the question is, for taking the long view, are we going to put ourselves in a position to manage our affairs, or are we going to put ourselves from a budgetary standpoint in a position to potentially have a federal court step in and do it for us? The latter is a very unappealing, as we all know, on any issue, possibility, and so we do better to go and dedicate that now. Again, it's just a floor. That's all it is, just a floor, and there's no new revenues involved. Thank you. I appreciate the question.
Mr. Neal.
Thank you, Mr. Chairman. Representative Gold, let me ask you, there are, frankly, quite a number of different specific budget items that would fit this description that's dedicated but ain't dedicated.
Sure.
How'd you come to pick this one? And, I mean, how'd this bubble up and you're not dealing with the rest of them?
Sure. I appreciate the question, and there's a very important distinction. How this came about actually is it's a priority of the State Bar of Georgia, and they've asked me to put it in, and I agree with it. The difference between, let's say, the Solid Waste Trust Fund is a good example, of a fee that gets generated for an intended purpose, but doesn't always get funded to the extent that it's supposed to. The difference is this, is that in the Sixth Amendment to the U.S. Constitution, it specifically provides, it's a constitutional requirement in the Sixth Amendment for us to go ahead and provide defense counsel, for the government to provide defense counsel. You have the right to remain silent, anything you say or do, et cetera, and you have the right to an attorney. If you cannot afford one will be provided for you. We've all heard that on television or wherever, and at the end of the day, that's as a result of the Sixth Amendment to the Constitution. So to the extent that we do better to control that system ourselves rather than having a funding inadequacy issue that has us in court, and we have been in court in several jurisdictions over the last several years on the adequacy issue, rather than running the risk of having a federal court step in at a time now or 2-3 years from now, we do better to set a floor, have that agency properly funded. Any surplus that exists goes back into the general fund. But that's the difference. The difference is the Sixth Amendment to the Constitution. I'd like to go ahead and dedicate this, those funds as well, to be honest with you, to have those fees used for the purpose that they're supposed to be used for. The difference is that while I support, and we all support, I think we do, the Solid Waste Trust Fund, that's not a constitutional requirement, whereas this purpose is enumerated in the Sixth Amendment clearly, and that's the difference. And I appreciate the question.
If you've got a question for Mr. Golick, raise your hand. I've got Mr. Willard.
Chairman Golick, I'm trying to think with regards to this is a department or a service that's under the executive branch, is it not, as far as the Council for Indigent Defense?
Yes, sir.
Do we have any other program or department that is having funds dedicated that really go outside of the ability of the executive branch to determine what those needs may be?
I don't know. What I do know is that the difference is that on this particular agency, we do have the constitutional requirement, and that's the reason. That's the impetus for it.
We have a lot of constitutional requirements, whether it be in health care and other things that we don't tell the executive branch. You must have no say-so about what would be the funding mechanism for that particular service. Is that true?
Well, I don't know if we're saying we have no say-so. What we're doing is let me finish, please, since you asked the question. We do have a situation where we're setting a floor that does not preclude the executive branch or the legislative branch in the supplemental budget posture or in the full budget posture from appropriating more funds if it's necessary.
Is it true every year we do that as a part of what we call appropriation bills? We
It does.
determine what the needs are, and then we therefore provide funding for that particular need.
And you've hit on the issue. You've hit on the exact issue, because in the last several years, we have had funding inadequacies. That's part and parcel of the recession. We've experienced that across the board in several agencies. The difference is that, as the gentleman knows 10 times better than I do, it's a Sixth Amendment requirement, and as a result, because of those adequacy issues, the Attorney General has been running in and out of state and federal court for the last several years, spending taxpayer money on cases that, had we had an appropriation, he wouldn't be defending those cases. And this is really more of a management issue than anything else for the future.
Ms. Smith.
Thank you, Mr. Chairman. Over here. Okay, I don't know the correct legal term, but we had a situation where several people were involved in a shooting that resulted in a death. So you have 5 defendants. And this is where my concern comes in, because I know this is what burned through the allocated funds in the beginning, is that there was not enough money to go around to fund the other cases. So have we dealt with the person's right to separate counsel on the same offense? Because to me, we're trying to put a limit here when we know that there has to be a lot of flexibility into how this is funded. We would be bankrupting the state almost if we provide a separate independent counsel with a certain, I mean,
You're absolutely
it's a boondoggle for somebody and it's not a boondoggle for the state.
You're
so
absolutely
I just want to know
right.
where that is.
You're absolutely right, and that's exactly why last year this General Assembly passed a governance reform bill of the Georgia Public Defender Standards Council, setting up straight line management between the director of the agency and the public defenders in the state. And where you have conflict situations, we have an amendment to a state bar rule that I believe is about to go into effect that allows for less cost in how we fund what are known as conflict cases, where you have multiple co-defendants, thereby getting a hold on the budget. That's exactly right, Chairman Smith, getting a hold on that budget and making sure those costs don't skyrocket.
Have we tested that and established what is a manageable amount? In other words, can we address this issue next year when we have statistics and data from this year that this is actually working?
Well, as of right now, by all accounts, from what I've been told, both by the agency itself and by the circuit public defenders who are out in the circuits defending these cases, our governance reform of last year is working, because we haven't had the issues that we've had in years past. So it comes under the category of no news is good news. If we didn't have that stability of governance reform from last year, we wouldn't be looking at this funding issue right now. You have to establish governance and stability before you tackle a funding issue. But the answer is yes, we have.
Thank you.
Ma'am, thank you.
Mr. O'Neill.
You say me? Yeah, Jerry, I have a question for him.
You got a question for him, Edward?
The chairman handled the question. Thank you.
I'd like to ask the committee to consider House Bill 930, population bill. Have to do with my judicial circuit and Wayne County Judicial Circuit.
Any questions for the leader? Thank you. Mr. Henry.
Thank you, Mr. Chairman. I'd like the committee to consider 2 bills on page 1, House Bill 786. This division of state government hasn't existed since 2004. This would save the state money for all these filings that are sent in. And also on page 2, under the modified structured, House Bill 730. This is the Fair and Open Competition in Government Contracting Act. It simply says that no government construction projects, bidders can't be required to participate in collective bargaining agreements with labor unions.
Ms. Sheldon.
Thank you, Mr. Chairman and committee. I bring for you today House Bill 634. It's a population bill dealing with interest on unpaid taxes for Gwinnett County.
Minority Leader.
Mr. Chairman, I actually had questions regarding Mr. Hembree's bills. If now is an appropriate time to ask these questions, or I can.
Well, it's never appropriate, but go ahead.
Thank you, sir. Mr. Hembree, first on 786, are these reports just not turned in, or can you explain a little bit more about the concern? Because according to the text of the bill, it seems like useful information to gather in case a member of the public wanted access to this information.
We have a state insurance commissioner, and the state insurance commissioner receives those filings. Back under the Barnes administration, he created the Office of Insurance Advocate, and so at that point in time, the law was required that these documents be sent to the insurance advocate as well. The position of insurance advocate has not been funded since 2004, and the state has accumulated over 700 boxes of these filings in these years. It has cost the state money to, they're stacked up in offices and the state warehouse. So if the office is not funded, then shouldn't be necessary for individuals to have to file these things, but they can get the information from the insurance commissioner's office.
Okay, thank you. One further question on HB 730. Would this language preclude a city or a county if it so desired to require these contracts? Would this be an interference with local control in making the determination of how they want to address their contracting?
No, I don't think so. It's just an issue of fairness and competition. We all have plumbers and small contractors in our areas, and this would just make sure that they have the fairness in the bidding process, and they would not be required to join a union in order to place a bid on a project.
But if I can direct you to line 13 and 14, it specifically says, and I just want to make certain, when it says, unless otherwise required by law, no governmental entity that contracts for public works construction shall, in its bid documents, require this information. So is the law that you're referencing, does this permit a local ordinance to require it, or does the state have to be the only entity that can require these documents?
It deals with both local governments and the state government. But what the point of the measure is that there should be open and fairness in the bidding process, and that if a project labor agreement is involved in a construction project, that the local government or the state government would not require that heating and air conditioning company to join a union in order to participate in the bidding process.
So this would preclude, so if the city of Atlanta wanted to put this requirement because they found it to be the right public policy for their city, the state would be telling the city it's not allowed to make that determination on a local level?
No, the state would just be saying let's have a fairness in the process by opening it up to all bidders regardless of what your participation in unions are.
But I'm asking a very specific question. I understand your intent is fairness, but my question is, does it specifically preclude the city of Atlanta or any other local jurisdiction from exercising local control when determining contracting?
It says the city of Atlanta must participate in fair and open competition.
So yes, it does preclude the city or any local government from making their own local control decisions. Thank you, sir.
Fair and open competition.
Mr. Lindsay.
Just a short question, Mr. Chairman.
Yes, sir.
This is a right to work state, correct?
That's true.
And this bill is designed to keep any government, whether it be state or local, from going through the back door, what we have already stated through the front door, our public policy that this should remain a right to work state.
That's correct.
Thank you.
Very well said.
Mr. Smith.
I'd like to ask again for House Bill 472, the brew pub distribution system.
Any questions? Thank you. All right. Passed up all your good opportunities. We're going to set the calendar. This is Tuesday's calendar. And I want to mention that I'm sure that Mr. Earhart wants me to know about those chickens. Okay, all right, let's go. Under modified open, HB 733. Any opposed? Under open, HB 635. Any opposed? Under modified open, HB 786. Any opposed? Under modified open, HB 886. Any opposed? Under modified open, HB 929. Is nobody going to object to that one? Oh, okay. Under modified open, HB 930. See, maybe we can get him out of the way and we won't have to see him anymore. Under structured, HB 895. Any opposition? Under structured, HB 472. We're having a problem up here. Any opposed? Under structured, HB 634. Any objections? That's the calendar.